Okay, record should reflect there's been a rather lengthy bench conference regarding this. Instead of setting it for exam, I think all councils agreed we're going to adjourn this out to March 12th, 2026 at 9. Bond will continue at this point as denied as I have it. And council will provide you copies of what came to the court.
Thank you, Honor.
That I saw today. All right, thank you. Court calls case. People versus Randall Laird.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning, Your Honor. Veronica Glenn on behalf of Mr. Laird. Laird. He's appearing by Zoom today.
Is he? There he is. Sir, please state your name.
Randall Laird.
All right, what are we doing?
Your Honor, my client would like to waive the preliminary examination.
He wishes to waive.
Yes.
Is that correct, sir?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single. Your turn.
Oh, Your Honor, my client stands mute and we will waive formal reading of the information and we ask that you set this case for pretrial.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 20th at 1:30 with Judge Hamoud.
April 20th, 2026, 1:30 before Judge Hamoud. Bond will continue.
Thank you, Your Honor.
All right, thank you. I think that's it for you, Madam Attorney General. Have a great day.
You as well. Thank you.
Court does call the case. People versus Marcus Claiborne.
Good morning, Your Honor. Sam Bernstein, current attorney for Mr. Claiborne.
And good morning, Your Honor. May it please this honorable court, David Burgess, on behalf of Mr. Claiborne.
Your investigation, Mr. Bernstein, indicated a potential conflict.
Yes, Your Honor.
All right. Mr. Claiborne, you understand that?
Yes, sir.
All right. And I don't have, do we have their order with Mr. Burgess? There it is. All right, I'll permit Mr. Bernstein to withdraw. Being no objection, the MAC office has appointed Mr. Burgess.
Thank you, Your Honor. Judge, I just
Sir, you need to keep yourself face this way. Go ahead.
got a family in the court. I'm sorry, Judge.
No, I understand.
Your Honor, we're asking for a brief adjournment. Judge, if I could get a week, I know you normally assign them. If I could get a week, I just don't want to.
1 week?
Yes, that's all I need. So.
Probable cause conference will be adjourned March 5th, 2026, 9 a.m. Bond continued.
Judge, could I briefly address the issue of bond?
You may.
Thank you, Your Honor. Your Honor, bond's currently set at 100,000 cash surety. My client is 18 years of age, has no prior criminal history. Understand the serious nature of the charges, but Your Honor, a cursory review of the discovery, it does not appear that there might have been some allegations of some gunfire, but it does not appear that there was a specific victim in the case, Your Honor. He does have family in the courtroom today. His aunt and father are present in court today, Your Honor. He does have a residence to reside at in Wayne County. A judge, if the court were to release him. Understanding the serious nature of the charges, judge, if the court's not inclined to reduce the bond, I'd ask for an additional 10% provision on the current bond. I don't believe he has, obviously has no history of non-appearance, Your Honor.
Response?
I don't think we'll object to any change in bond at this time. This is an incident where the defendant engaged in shooting up a house that was residing. I believe there were 5 people in the house. We're lucky that no one was hurt during that incident. but there was fully automatic weapons that were recovered here as significant safety concern, given the conduct as well as the fully automatic weapon. If he were to be released, I don't believe that any change is necessary at this
You're
time.
saying that weapon was recovered from this defendant,
Let me double check to see which individual that weapon was recovered from, and I can get that to the court.
but, okay, but all of these folks were together. The weapon may have been recovered from another of the individuals. Is that?
It may have been, I don't remember off the top of my head, so I'm looking at the report right now to see who exactly the weapon was recovered from. There's some additional information on that we can approach off the record to discuss briefly on that as well.
Since I'm adjourning it out a week, I'm not inclined at this time to reduce his bond or change it.
Understood.
At this moment. So I'm going to deny your request to change bond.
Thank you.
So bond will continue in this case. Thank you. Court calls case People versus Taj Smith.
Bring to the people.
Good morning, Your Honor. Robert Ellman on behalf of Ms. Smith, who I believe should be present over Zoom.
Taj Smith.
If she's not, Your Honor, I would ask that you please pass this matter. I've been in communication with her this morning and I did expect her to be on here. I've been texting with her all morning. I apologize. Thank you.
Court does call the case People versus Marquetta Clements.
Your choice of appearing on behalf of the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Clements, who's now approaching. Can you please state your name to the record?
Marquetta Clements.
I have before me a plea form. Is that what we're doing?
That's correct, Your Honor.
The plea form indicates that the defendant would be pleading guilty to the charge of attempted resisting and obstructing a police officer, first responder. That's a 1-year offense. Upon her successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
Well, also I should say that the defendant is agreeing to pay all restitution, any and all restitution.
Yes, Your Honor.
All right. I have her sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Marquetta Clements.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 district.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand by pleading guilty, you'll not have a trial of any kind.
Yep.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yep.
Yes?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce?
No.
Doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty?
Yes.
On September 1st, 2025, at the location of 501 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with police officers of the Ypsilanti Police Department?
Yes.
What happened?
I resisted arrest. They tried to arrest me at Tom's and I did not go. I did not comply.
Okay, I get you, but what did you do when they were trying to arrest you?
I sat on the ground and then I rode.
Okay, so you were trying to stop them from putting handcuffs on you?
Yes.
Okay. And you would admit that that interfered with what was their lawful duty at that moment to arrest you?
Yeah.
All right. Ma'am, I do have to advise you, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. The pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
March 11th at 10 a.m.
March 11th, 2026. What time? 10 a.m. before Judge Barr. Bond will continue. Thank you.
Here's a pivotal moment. Marquetta Clements pleads guilty to attempted resisting and obstructing, avoiding trial while counts 1 and 2 get dismissed. She admits sitting down and resisting handcuffs. The judge carefully confirms voluntariness and rights waived. A misdemeanor today, but convictions carry consequences. Smart deal or risky admission?
Case of People versus Alyssa Arbiter. Alyssa Arbiter.
She's on Zoom, Your Honor.
State your appearance. I don't have her.
My name is Elisa Arbiter.
She's Samsung.
Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Senior Assistant Public Defender Joy Gaines.
Permission to practice is granted.
Thank you, Your Honor.
Ma'am, I need a camera, please.
Okay, one moment, please. I gotta try to figure out how to do that. Start my video.
That did it. Thank you.
Thank you.
All right, what are we doing?
We're adjourning for negotiations, Your Honor.
Requesting an adjournment on this. Probable cause conference will be adjourned to March 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
We'll be in touch, Ms. Arbiter.
Thank you.
Thank you, ma'am.
Thank you.
Court calls the case People versus Theodore. Is it Ankney?
Check kind of people, Your Honor.
Assistant Public
Assistant Public Defender Chinazi Carey Akinruli, Your Honor, on behalf of Mr. Theodore Ankney.
Theodore Ankney, the third.
Third? Okay. All right, what are we doing?
Your Honor, we're asking for an adjournment. The people sent over a request for a signature on a protective order, which I did give today. I think the court just received it. So we're asking to adjourn so we could review that.
I don't have it, but
20 minutes ago.
Yeah.
Today.
On time. Okay. You have it printed. I know you're working. I don't know what they're doing. All right, I'll sign that.
Thank you, Judge.
How much time do you think you need?
I think 2 weeks should be fine, Your Honor.
Probable cause conference, March 12th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Let's call the case People versus Ashana Barrett.
Ally Zend on behalf of the people, Your Honor.
Judge. Public defender on behalf of Mr. Barrett, who should be approaching the podium. Please state your name for the record.
Shawna Barrett.
Thank you, Judge.
Sorry.
Just get a PR. I don't.
You should be in receipt of a green sheet, Your Honor. That's
I am.
adjournment,
You
but
aware of the violation?
yes, Judge. There is a bond violation in this file, and I know that the court would want to address it, Your Honor.
Yes.
Thank you, Judge.
This is the DB case and she was in contact with the protected party.
Yes,
I'm not even sure how, after arraignment, she got a PR.
I was not there either, Judge. I don't know either. All I can say on behalf of Ms. Barrett is that obviously she apologizes for the not following the court's order. And she has an excuse, but obviously it doesn't justify her being in contact with the protected party, Judge. I did tell her that Your Honor was not going to be happy with the facts of the violation and what the court was likely going to want to do based on her being in contact against the court's order. She still showed up to court and she did not run or leave this morning when I reiterated that she may not be going through the front doors today. What she wants me to let you know, Judge, is that obviously she has a small child, a 2-year-old son, and she has financial difficulties. I believe that she was in contact with the protected party because that person had a car and it allowed them to do DoorDash together so that she could make money to buy diapers for her child. She apologizes for not following the court's order, but that is an excuse for why she did not do so. And she's asking Your Honor to consider giving her another opportunity. And she says she will not make that mistake again, and she will follow the court's order next time. But she doesn't have any other justification for why she violated the court's order, other than she was trying to provide for her child, and she has no other family or support here, and she needed to use that vehicle. That's how they were stopped, Judge. The vehicle did not have a proper license plate on it. And I believe that's how they were stopping the vehicle while they were doing DoorDash. And that's how she was brought back in the car.
Well,
Your Honor, I have concerns with the DB case the court stated, and there's no contact, means no contact. I also concerns that the reason for it was to take care of the child. The child was in the car at the time of the DB incident. So frankly, I think there should be a no contact with the child, given that the child was in the car for the part of the best as well. But no contact means no contact, no matter what the excuse is. This is a domestic violence charge, felony charge. So at this point, I would ask for a remanded due to law violation.
I'd ask the court not to put a no contact order against the 2-year-old child. Obviously, that child would not be testifying in this case, and there would be no jeopardy to the child in this matter. But I do understand the people's request for a remand based on the
I won't add that condition unless I have additional information regarding the no contact with the child, if there's some type of CPS, something, but I'm going to adjourn the probable cause hearing to March 5th, 2026, 9 a.m. At this point, given the violation, defendant's bond is hereby ordered to revoke. Defendant's remand is lifted.
Come back and behind the table. Thank you, Judge.
Thank you. Court does call the case, People versus Mario Crawford.
Raymond Cook for the people.
Good morning, Your Honor. Monica Glenn on behalf of Mr. Crawford. Mr. Crawford, can you state your name for the record, please?
Mario Crawford, Your Honor. Thank you.
Your Honor, we are requesting an adjournment in this matter, and I would like to address bond when appropriate.
I have a green sheet.
Yes.
So wait. Okay. I see what she's done. Turn the matter to March 19th, 2026, 9 a.m. All right, as to bond.
Yes, Your Honor, we would like to request that our client be released to treatment.
I have that order. There's no objection from the people.
Correct.
So I will sign the order that will allow release to treatment.
Thank you.
All right. Huh? Well, it would be released on the teller, yeah. All right, bond will continue. Thank you.
Thank you.
Now, this is different. Mario Crawford isn't fighting bond, he's asking for release to treatment, and prosecutors don't object. That signals cooperation and rehabilitation over punishment. The judge signs off. In criminal court, treatment-based resolutions can change trajectories. Accountability doesn't always mean incarceration. Sometimes it means intervention.
It does call the case, People versus Walter Peterson. Oh, where's Peterson? Yeah. Oh, there he is.
Good morning again, Your Honor. Robert Ellman with and on behalf of Mr. Peterson, who I believe is present over Zoom. Mr. Peterson, can you please state your name?
Walter Peterson.
Your Honor, the people and I have been diligently working on a resolution of this case. However, we do need some additional time. I'd be asking for an adjournment at this time.
See, are these the only things he's held on?
He has these cases, and I believe he also has a misdemeanor in front of Your Honor that's set for next week for pretrial.
March 12th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court does call the case People versus Riley. Is it Everett or Everett?
Portia, Assistant Public Defender, on behalf of my client, who is approaching the podium. Please state your name when you arrive.
Riley Everett.
Thank you, Judge. We are requesting an adjournment in this file. We are seeking to try to negotiate a further resolution. Mr. Everett would like me to address a bond condition, please, Judge.
Is this the only thing holding him?
Yes, Judge.
Go ahead.
Yeah, he's just requesting that Your Honor consider treatment. I believe that might be part of how he got himself in this situation.
So you want to release the treatment?
That's all, Judge.
GPS. All right. Then what I'll do is I'll adjourn this out to March 19, 2026, 9 a.m. A little bit longer. His bond will continue, and if I'm given an order for release to treatment, I'll sign off on it.
Thank you, Judge.
All right. Thank you. That's called the case People versus Anthony Turner.
For the people.
Morning, Your Honor. Edward Rooks on behalf of Anthony Turner. Should be on Zoom.
He's refusing.
I'm asking for an adjournment. I have discovery accepted video, so I'm whatever the court would like.
Anything to be seen, then I'll adjourn the probable cause conference to March 26, 2026, 9 a.m. Bond continued.
Thank you.
Is this your case or Burgess?
Anthony Turner? I understand mine. Discovery was sent to me.
Well, it is. We just have it wrong at the top. We got it.
All right, thank you.
Court calls case People versus Denard Gray.
As and on behalf of people, Your Honor. Section 10 on behalf of
Behalf of who?
Mr. Griggs, Denard
That
Gray. I was so close, Your Honor. I'm sorry. I was talking to another client about an offer that just came through. My apologies.
Sir, your name?
Denard Gray.
Thank you.
Your Honor, at this time, we are going to be asking for an adjournment of the matter
Why are you yelling at her?
because I was talking.
Why were you yelling at her?
I wasn't
So,
yelling at her. I was
yes, you
celebrating
were.
her.
You were like demanding that she do something.
Oh,
Why were you doing that?
I was celebrating her independence, Your Honor. That's all. Sorry. You're asking for a brief adjournment of this matter so we can see if we can negotiate and or mitigate this down a little bit for my client. Your Honor, we'd also like to address bond when appropriate.
Okay. So you're looking for a brief adjournment and Ms. Zenda has risen,
Oh,
which
no.
means we're probably
She didn't mean to.
we're gonna get a bond thing anyway.
She didn't
So
mean to stand up.
I'm gonna, Ms. Zenda, I'm gonna let her roll. Go ahead.
Your Honor, it has come to my attention that Mr. Gray has made 4 calls to the victim since his agreement. In these calls, he states things, asking her, can you not leave me? You promised me to stay with me. Stop listening to her as in her mom, who was also mentioned in this case, and just tell her the truth. When we get to court, can you tell him to drop it, or that you can just tell him the truth? So at this point, I'm going to be asking for his own preliminary vote. I'm also going to be re-requesting our original bond of $500,000 cash surety for this case. This case involves 3 separate incidents of domestic violence with this victim, including the defendant taking her phone when she wasn't talking to anyone. She wakes up to go get her phone. He then catches her trying to get the phone, punches her in the face numerous times. Another incident, he was controlling her eating and sleeping. And an argument began. He told her she had to stay in her room, but she left, and then he beat her for leaving the room. He hit her in the head and the body about 10 times with his fist. He also hit her all over her body with a broom. He also punched her in the eye multiple times. She then fled to her mother's house to go to the hospital. She had a black eye, memory loss, bumps and bruises all over her body, cuts and bruises on her nose, eye, cheek, bruise on her lower back, a concussion, a contusion of her face and ribs, and back pain. Her mother, who she fled to, also made a report with Inkster police for him sending her a picture of a gun with threats associated with that. If I can just do that.
This is explosive. Prosecutors detail alleged domestic violence, threats involving a gun, and repeated calls urging the victim to drop it. That's not romance, that's potential witness interference. The courtroom tone shifts instantly. When safety and intimidation collide, bond isn't just paperwork, it's protection.
Stop, please don't come to my house. Please give me my wife back. Don't let them people think I won't kill them for coming to my house. I'm a man of Yah. So at this point, I'm going to be re-requesting our original bond. The victim also mentioned in the report briefly other possible strangulation incidents and other instances of the defendant possibly putting a gun to her head. So there could be also more charges including depending on conversation with the victim. So at this point, I don't believe that the bond as set with 50,000 cash surety is appropriate. I would be re-requesting our $500,000 given the facts of this case, and that he is continuing to violate his bond and the no contact order, and would also be asking for his home.
Response.
Your Honor, as far as the text messaging with the weapon, that was in a direct response of them threatening him and threatening to come to his house. So, and she even read that, tell them don't come to my house. If they come to my house, I will defend myself. So, and that's what those text messages say. They were not a reach out to threaten anyone. They had been threatening him. And this was his response to those threats. He could have done better in how he chose to deal with that. And we've discussed that, but the threats in that matter were more like a self-defense. He was not trying to do anything. He wanted them to leave him alone. As far as those go. Your Honor, I spoke to my client yesterday and I was exceptionally clear that he is, even if it is just to tell someone that you love them and that you're still husband and wife and things of that nature, he cannot reach out to the complaining witness because the court stated that that is something he cannot do. Your Honor, I do want the court to know he has a stable home. He has a job. He's a chef at Villa Park Ridge. The complaining witness lives with her mother down in Inkster. He has dogs who are currently at the shelter and they're about to be turned over for adoption and or euthanasia, depending on the status. He has been on his own since he was 17 years old. He doesn't have anyone else, it's just him. But he doesn't want to lose his home. He doesn't want to lose his job. He doesn't have a car, so he can't get to Inkster. I explained to him once again, Your Honor, that he cannot have any contact, period, with the complaining witness if released on bond to his home. My client has assured me that he will not be making any contact with the complaining witness.
And you're actually going to get to the court. The calls weren't just "I love you." It's come to court, do what I told you to do, tell them that that's not what happened. A direct quote: "When we go to court, can you tell them like to drop it, or that can you just tell them the truth, bro?" Later asked her again in another call, "Can you just please just do what I need you to do?" Okay, so it's not just love; it's interfering with the criminal process here. So I have concerns that we cannot follow court orders to not contact the victim and interfere.
Having heard the argument in this case, I'll adjourn this matter out to March 12th, 2026, 9 a.m. I will grant the request of the people finding an abuse of discretion to accept the bond where it is. His bond will be increased to $500,000 cash surety. Defendant's phone privileges as well as texting privileges are hereby ordered revoked.
Thank you.
Thank you. Court does call the case of the people versus Bridget Beck.
Michael Gray, Assistant Public Defender on behalf of Ms. Beck, Your Honor, who should be here by Zoom. I thought I saw her this morning.
I do see her. Miss Beck? Really? Beck?
There she is.
Good morning. Can you state your name?
Bridget Beck.
Thank you.
Your Honor, we're requesting a brief adjournment. I'm going to get some information to Mr. Zablowski that hopefully we can resolve this matter.
Cause conference will be adjourned to March 19th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. I'll be in touch, Ms. Beck.
Okay, thank you.
Court does call the case people versus Joseph Jusba Odin. Your name, sir?
Here, nuance matters. Joseph Odin faces resisting and controlled substance charges, but defense argues no assault occurred. Yes, he allegedly made reckless statements, but no punches were thrown. The judge grants a 10% provision on $10,000 bond. Words carry weight, yet proportionality still guides the court.
Your name, sir?
Also, Jusba Odin.
Ms. Atkins, release case.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Jusba Odin. Did I say that correctly? Okay. I apologize, Your Honor. Your Honor, have we already set this matter for preliminary examination?
I haven't done anything.
Okay.
We're all waiting for you.
I-
Joy was just filling space.
Thank you, Ms. Assistant Public Defender Chinazi Kyriakin, Your Honor, on behalf of Mr. Odin. Have you stated your name for the record? Your Honor, we respectfully request that this matter be set for preliminary examination, and we'd like to address that.
Discovery is complete.
To our knowledge, Judge, yes.
People have their witnesses available the 10th.
Yes.
Preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington.
Thanks, Judge. In regards to bond, Your Honor, Mr. Odin's bond is currently, I think is it 20,000 cash or surety?
I have 10,000.
10,000 cash or surety, Your Honor. Mr. Odin is not able to post that amount. This is a resisting and obstructing charge. I know that there's also a controlled substance charge associated with it. However, this is pretty much the only case that is holding Mr. Odin.
Pretty much?
Yes, Your Honor, there was, sorry, there is a child support case that had been waived up to circuit court. We were able to get him a bond of, I think it was $700 is what the bond is right now. He is able to post that bond, but until, I obviously instructed him not to post that until we can determine if we can get a lower bond in this case. He is not a flight risk, Your Honor. This is a non-dangerous, I understand that it's a resisting and obstructing, and the people may very well say by the nature of the title of the charge, it may be an assaultive case, but it is not an assaultive case. He did not have a fight with the officers. There are no allegations of him striking any officers. Your Honor, this is a case where my client was driving in the winter storm, and for whatever number of reasons, officers pulled him over. He was subsequently arrested, and he had a lot of questions about that arrest. I may be minimizing it just a tad bit. However, Your Honor, this is not your run-of-the-mill case where my client runs from the police, where he actively fights with the police. This is a case where I think a lower bond would allow him to be able to post it. There are some evidentiary issues that we would like to address, and we would, it would be much easier if we had his assistance out of custody to do that.
Response from the people.
During the incident in our case, as Ms. I can really point it out, in the bond form, the defendant apparently is quoted as saying, "I will punch the expletive out of the officers." I think that's probably said.
That's what he said?
Well, no,
Well, yeah, but, okay, he might get one punch and then it's gonna be over. So that's a stupid thing to say or even try to do.
It's always good to know how many officers are going to use, Judge.
Yes. Anything else we're thinking of?
Nothing else at this time, Judge.
I will adjust this bond. I'll give him a 10% privilege on the 10,000. So I'll do that, but gotta think about what he allegedly says. That's probably the other reason it's here.
I understand.
That's just stupid.
He and I have talked about how things would be different if, and he's taken accountability for that part, Judge. So we are appreciative of the reduction. Thank you, Your Honor.
And I wish he had taken a swing. What would have happened? I'm kidding. I'm kidding. I'm not saying. People just need to think it through. Court calls the case, People versus Marcus Jones. Zoom.
Judge, Torshell Feaster, Assistant Public Defender on behalf of Mr. Jones. Mr. Jones, please state your name for the record.
You're not. Can somebody, we're trying to unmute you, Mr. Jones. Oh, there he is. State your name, sir.
Marcus Jones.
Thank you.
Thank you, Judge. I was going to set this for exam, but Ms. Itiria-Kanruli's been negotiating a little bit more with the people, and we may be able to consider mental health court. So if we could adjourn this for a couple weeks.
So you're going to be looking into the drug court for him?
Mental health court.
Mental health court from. What's the time frame? I mean, I put it out a couple weeks, but I don't want to come back and then.
So like,
let's just do a couple weeks.
Facility or something like what?
Pardon?
Say you sending me to a mental facility or I'm staying here?
No. That's not what they're trying to do. Here's what I'll do so you can explain it all to them. I'm going to go to the 19th, 2026, 9 a.m.
Thank you very much, Judge.
And you can explain it all to Mr. Jones is what you're trying to do for him.
Yes,
and everything. Okay. All right. Thank you, Mr. Jones. Court calls case People versus Brian Laster.
Hannah Mackey on behalf of Mr. Laster is approaching.
Mr. Laster, look at me. Counsel, state your prayer.
Oh, Hannah Mackey on behalf of Mr. Laster.
Your name, sir?
Brian?
Laster?
Yes.
Your Honor, we're adjourning this matter. We tried to meet with Mr. Lasker in the jail. However, he would not meet with us.
You didn't want to meet with your attorneys? Why?
I did. I don't, that's the public, this is not my attorney, the public.
No, the public defender's office is your attorney. So when they come there, you should meet with them.
So I went, the person that relayed the message said it was either a professional visit or the judge wanted to see. So that I wasn't, no kite.
I'm gonna give you, they can't do anything for you unless you meet with them.
All right,
So
I didn't get
you
any
don't
kite.
get a choice as to who's coming.
Yeah.
So here's what I'm gonna do. I'm gonna adjourn it out at their request so they can try to meet with you to the 19th,
Okay.
2026, 9 a.m.
Okay.
Bond will continue. Thank you.
Yeah, that's fine, that's fine.
Okay.
The
I'm glad
19th,
you
what
like-
month?
Pardon?
What month?
March 19th, next month. You need to keep moving. Keep moving. So, Eckenrule, is that your fault?
My phone?
No. Is that your fault? Who was it? It was your fault? Why? Huh? He wanted to see you. I don't know who went down there, but he didn't like that. It was you?
He declined the invitation.
He
He declined the invitation.
He would not meet with Joy Gaines? I'm glad I didn't know that before. I would have revoked his bond. You're not gonna meet with Miss Gaines.
This is in my car phone. That's in case he wants to just call me, Judge.
Okay, all right. Court calls the case. People versus Bernard Brock.
Morning, Your Honor, Raymond Cook for the people.
Hannah Mack on behalf of Mr. Brock, who should be on Zoom.
Yeah, I'm here.
Okay, state your name, sir.
Bernard Eugene Brock, Your Honor.
Thank you. You're seeking an adjournment.
Yes, Your Honor.
From waived exams to bond revocations and mental health court discussions, today's session proves one thing. Courtroom decisions move fast and consequences move faster. Some defendants gained opportunity, others lost freedom. Every word mattered. Like, comment, and subscribe for more shocking courtroom stories and legal breakdowns.